Hello and welcome to another edition of Coffee Talk with attorney Brian D. Lerner. In this particular episode, I'd like to talk a little bit more about incompetency hearings and how one can be determined to be or not be. Excuse me. Now you can tell that the video is live. What is and is not determined when you're in an incompetency hearing, because as anyone watching this knows, you're either on the side where you're claiming that the person who signed the will or the trust was totally competent at the time because you want essentially what it is that they're bequeathing to you, or you're on the other side which says no, the person was completely non-competent and incompetent at the time of signing the will or the trust, and therefore the actions of whatever are in that particular document should be disregarded. And so I've made other videos on the matter, but because there's so much on incompetence hearings, I thought I'd put a little more detail in it today. So in this particular situation, there are actually hearings that you have in probate court. And remember, you don't have to go and actually open up a probate hearing in order to go into probate court. You can either be in a trust or have some issue that you need to bring to the probate court in order for them to, the judge, to make a decision. So you will get a judicial determination of incompetence or a judicial determination that there was competence, whatever, after all of the evidence is submitted. And one thing you have to be crystal clear on is that it is very factual specific. It's not like some other areas of law or some other areas whereby, if the statutory elements were violated, then the person is deemed, to be ABC or whatever. In this particular area, one person might be judged to have been incompetent, whereas another person with similar facts, but not exactly the same facts, might be determined to be incompetent. So it really depends. So you do need to get your ducks lined up and get your arguments on whichever way it is that you happen to be going. So sometimes people will try to show, well, this person who signed cannot conduct business, and therefore is incompetent. Well, that won't work. The testator's ability to transact business is not a legal standard for testamentary capacity, so it has nothing to do with it. So next, a lot of times what people will try to do is go on and submit evidence regarding the history of the mental disorders that the person has. Well, that's certainly factual, it certainly is relevant, but just because somebody has a history of mental disorder does not mean that they're incompetent. Of course, it doesn't automatically mean they're competent either. It will depend on the circumstances of the case, and you show when the mental disorder began, what it was, and of course it's not just you saying this, it has to be medically diagnosed and so forth. And then you have to show that at the time the signing of the will or the trust, that the testator was being affected by this mental disorder, and that the person did not know or understand what it was that they were signing. So as you can see, having the mental disorder by itself doesn't mean right off the bat the person's incompetent. Having the mental disorder at the time of signing the document still does not automatically mean the person's incompetent, because you still have to show that the person did not know or understand what they were doing, even with the mental disorder, and that it was affecting them at the time they signed it. So just as a thread of theory here, the law seems to want to push towards a determination of competence and make it very difficult to show that a person was incompetent. So you have to understand that if you're going to try to show that someone's incompetent in signing something, you've got an uphill battle. The law is hedged against you in order to basically, I think, to decrease the litigation on everybody going forward and saying, oh, the person was incompetent, therefore take away what they did. So, if you're going to show their incompetence, you really have to show. So, there sometimes people will bring into the hearings, eccentricities of the person, mental irregularities, departures from the normal, old age, feebleness, forgetfulness, personal habits, and so forth, failure to recognize old friends or relatives, physical disabilities, absent-mindedness, all that. But that, again, all of that does not establish that the testator lacked capacity. There are even cases where hallucinations and delusions do not show lack of capacity if they're unrelated to the testamentary act. So, unless they were seeing their great-great-grandmother ordering them to, sign something at the time they were signing it, you can't use or hope that a delusion or hallucination will help you there. Now, again, it doesn't mean it won't. Okay, I mean, you bring in enough evidence about all of this stuff, the mental disorders, the delusions, and so forth, maybe you'll persuade the judge the way you want to go. But again, don't make the mistake that a lot of people do, that just because someone can't remember who their family is automatically means that they are incompetent. Okay, so there's also what's called senile dementia, which as they get older, there's more memory that gets lost. There's actually what's called chronic brain syndrome, decay of brain tissue, general incoherence. Again, you can use all that, but you do have to show at the time they signed the document. That's where it all comes down to. At the time they signed the document, they were unable to understand what they were doing and did not know what they were doing. Okay, so that's the key time that everything has to come to. You can't just say, oh, well, the person's had dementia, senile dementia for the last 22 years, therefore could not possibly have signed a document knowing what he or she was doing. No, you have to get specific as to the time. Sometimes they will bring in alcohol or drug abuse. Okay, and again, I don't mean to keep repeating here, but unless it can show at the time they signed the document that it affected them in such a manner that they did not know what they were doing or did not understand, even if they are a drug abuser and or a chronic alcoholic, they still can be ruled to have capacity to have signed and done what they did in regards to the trust or the will. So as you can see, there's lots and lots of different ways of going in on this particular matter. If you want a free consultation anywhere in California, give me a call. Give my office a call. They'll set it up for you, and we'll go from there. More in the coming videos.